Queensland Court has thrown out the case against 3 QUT students who were accused of racial discrimination after they sat in computer chairs designated for indigenous students, and then, after they were kicked out, complained about it on Facebook. Joining me now is Sky News Brisbane Bureau Chief Elizabeth Tilley, who was at court. Liz, obviously some relief for the students involved.
Yes, certainly was. Actually, I just spoke briefly to Calum Thwaites, one of the 3 students, and he didn't want to speak on camera as he's got to rush home to his mother now. So obviously it's been a pretty anxious wait to find out. It's been 3.5 years, in fact, this legal battle that has gone on for these 3 students, and hundreds of thousands of dollars in legal fees as well. Now that this case has been thrown out, it really seems like that's all been for nothing. So this afternoon, here in the Federal Circuit Court in Brisbane, we saw Judge Michael Jarrett hand down the decision in this case, and it is against those 3 students I mentioned: Calum Thwaites, Alex Wood and Jackson Powell. They had a case against them under Section 18C of the Racial Discrimination Act. It was brought by a QUT Indigenous employee, Cindy Pryor, who had accused the students of racial vilification. She was seeking some $250,000 in damages relating to an incident back in 2013 when a series of Facebook posts were made by these students after they'd been turned away from her at an Indigenous-only computer lab. She said that that was racial vilification and used Section 18C of the Act to try and argue that case. We know now, though, that case won't proceed. The judge didn't give any reasons for that, and he says he's going to publish them online, so obviously we'll look into that in more detail. But the lawyer for one of those students, Calum Thwaites, did speak briefly outside court just a moment ago, and he said very scathingly that there's only one person to blame for this case being brought in the first place, and that's the Human Rights Commissioner Gillian Triggs. He says that she should have stopped it from happening in the first place, and he also said that it does now mean that there should definitely be reform when it comes to Section 18C. Of course, we know that Prime Minister Malcolm Turnbull has been under pressure to make some of those changes, either amendments or repealing that section. And earlier today, Laura, as you know, he probably gave one of his strongest indications yet that he is willing to support a parliamentary inquiry into freedom of speech. And, you know, we know the question has certainly been around the words insult or offend. And Tony Morris QC, who was the lawyer for one of those students, said that those words should definitely be taken out of Section 18C. But this is a landmark case, despite it now being thrown out. It really will put the spotlight back on this discussion and certainly reignite the debate about freedom of speech nationally. Laura?
Absolutely. It has been already a very fierce debate. This has already been welcomed. This decision by the court today has been welcomed by a number of politicians on the right of politics. We're going to be speaking to Erica Betts and also the Institute of Public Affairs a little later on today. Elizabeth Tilley, thank you so much, and do bring us any reaction outside court if there is any more. Thank you for the update.